Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your Constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. The late evening U.S. people. Hi, everybody. How we doing? Good morning. Good morning. How are we all? How are we all? I'm here. I'm well. I'm alive. Doing quite well for being awake for just a few minutes. We kind of rolled straight out of the bed, strolled straight over to the coffee machine, and just pouring my first cup of coffee here. Excuse me for just 1 second. All right. We got our morning caffeine, so hot. Okay. A little hot. Okay. Well, there are developments here in the Maya Kowalski case. Just when you think things are wrapped up tight for a while, new things happen. And I got this yesterday, so here we are. I have a thing though. There's a thing. I have a problem. I thought I had a copy of the November 5th motion for sanctions against the J. Hatch lawyers. I thought I had a copy of that motion, but apparently I have gone and deleted or something. I no longer have a copy of the November 5th motion for sanctions. I'm just throwing this out there to you guys because this is what a professional person does. They don't check, a professional never checks anything before they go live. They never prepare in advance because they're too professional for that. They just wing it. If anybody here has a copy of the November 5th, 2023 motion for sanctions, please email that to me immediately at thelegalvices@gmail.com. That would be great because I would like to review that before we go into the new motion that was filed, the new motion for sanctions. But I don't have it. And that's actually what I was doing. I was scrambling around for 10 minutes trying to find it. Perhaps I should have scrambled around for 20 minutes, realized 10 minits in that I don't have it, and then gone to the court site and downloaded it. But if any of you have that, that would just be awesome. If it just
suddenly appeared in my email. But let's kind of pick us up. In the meantime, let's just kind of pick it up where we left off, shall we? Right. I do want to go back in history a little bit. I can go back as far as December 28th. Oh, that's interesting. Porcelain Thunder said, how did I get forwarded over to his next stream? That happened to someone else apparently the other day too. Anyway, so we know that they got their $261 million judgment. And recently that $260 million dollar judgment was reduced a little bit. We're still north of 200 million. So there you go. Oh, Jules, you are just a mensch. You are just an absolute amazing, wonderful person. Thanks, Jules. I had it, but I don't have it anymore. So yeah, let me know when you send that over, and then we'll download that. But those of you that followed the Maya Kowalski trial will know what I'm talking about. But right now we've got how many people here? We got 222 people here. Some of you may not be overly familiar with the Maya Kowalski case. I'll try to summarize it as best I can. And maybe you've seen the documentary, the Take Care of Maya documentary that was on Netflix. That's a great source for a little in-depth deal on what was going on. But they did get their huge verdict, and that was a long, well-fought battle by the plaintiffs. Led by an extraordinary lawyer, Greg Anderson. Greg Anderson he's not just a great lawyer, he's a great person. Had the pleasure of having him around the channel. We interviewed him. It was a great discussion. He's just an all-around good person. And he fought the good fight and he won. He won the battle for his client. But it was a long, nasty journey. It started out, don't jump me for the facts here, but because I'm giving a very, very, very succinct version. The very, very succinct version is a very young girl, Maya Kowalski, starts having some pains. She's dealing with the pain. They diagnose her with chronic pain, and with a chronic pain syndrome. And she's being treated for that. She was even treated for it a couple of times at Johns Hopkins All Children's Hospital. At some point, the wrong people, all the wrong people get involved. And the focus shifts from treating her for her chronic pain syndrome to focusing on her mother. Her mother, who was a Polish immigrant, she was a registered nurse, started focusing on her for having Munchausen's by proxy. In other words, they started focusing on the mother for torturing their daughter so that she could get the attention. She could get the help. So she could be seen as this hero who's trying to save her daughter, basically torturing her daughter for her own benefit. That's what they started looking at. CPS gets involved, the hospital gets involved, and eventually the hospital takes this young girl prisoner. They literally say she cannot leave the hospital despite her parents wanting to take her out. And that begins her in-hospital journey with this horrifically debilitating sickness she's got, this disease she's got, this illness. And they describe it as just every inch of your body being on fire and just the worst pain you can imagine. Thank you, Jules. I got it. You're the best. So and they're doing things. They put her in a room with a video camera without telling her parents they were going to be videotaping her and monitoring her. They wouldn't let her parents see her at this point. They wouldn't let her play with any other children on the ward. They wouldn't even put her name on the door. And they would do things to try to trick her into proving that she didn't have this illness. And it would lead to things like her defecating on herself because she couldn't get to the toilet. I mean, it was horrific. Then when they were getting ready to take her to court, there was one particularly horrific incident where they basically stripped this 14-year-old girl and took photographs of her body against her will twice. Well, she says once, the hospital says twice. I don't know why the hospital would say twice, but they do. And it eventually led with the mother having to move out of the house because of protective orders, and they wouldn't let her. And it got to the point where her mother decided the only way that the family could be together again was if she wasn't alive. And so her mother, she was 11 when that happened. Okay, yeah, I guess, yeah, okay, whatever. It's I thought she was 14 when they were taking the pictures, but yeah, I guess it would be going back. All right. Anyway, the mother decided that was the only way that they could keep the family alive or together was if she wasn't alive anymore. So her mother checked out. This hospital tortured a child, took photographs of her naked body, broke up a family, and drove the mother to check out permanently. They drove her to death is what they did. So during all of this, the hospital keeps doubling down and doubling down and doubling down. Their lawyers are denying everything. They're continuing to make everybody else responsible rather than the hospital, even when it's clear that they're losing this, even after they lose it, even after they lose this case and are nailed with this $260 million judgment. They go after the jurors. They go after juror number 1 for jury misconduct. Absolutely, completely barely acknowledged by the judge. The judge knew it wasn't even happening, but they had to go through the motions. They went after everybody involved, and they're still fighting tooth and nail. Still fighting tooth and nail to avoid paying anything on this horrific thing. And during all of this, the lawyers acted like a-holes, basically. They were not... As a lawyer, I hate this because, there's lawyer jokes out there. Everybody hates lawyers anyway. Everybody hates a lawyer until they need one. And then suddenly they're your best friends. that's how that works. But I guess I'm just a nice guy because I don't understand lawyers that behave badly. I don't understand lawyers that are purposefully mean and nasty and vindictive. I don't get it. I don't understand it. Life's too short for that. Plus, why not be a beacon to your profession? Whatever your profession is, why not be something that people can look up to, something that someone can emulate, something that people go, wow, that is a stand-up guy. Why would you have to race to the bottom of the snake pit? And that's what they've done. They've raced to the bottom of the snake pit. Right, we're gonna get into these motions here, but first I just want to say hi to everybody. So we got 285 people, and we've seen people we haven't seen for a long time. Steph, hi Steph, it's good to see you. It's been so long since we've seen you, Steph. Oh, I hope you didn't leave already because I saw 10 minutes ago you said I'll catch you soon. Oh, good. You should still be here. Steph, it's good to see you. Nick is here. Hey, Nick. Hey, a special. Oh, people are saying you forgot to mention this. You forgot to mention that. You forgot to mention throwing away the Eucharist. With this case, you cannot list everything this hospital did that was horribly wrong because it would take weeks, if not months, to do this. I mean it's not funny. It's not funny that this happened, but it's one of those things that's like so bad it's laughable. Sorry, the dogs are chewing on something. Don't chew on that, buddy. Thank you. Do you know what I mean when I say it's just It's laughable that it's so bad. It had to be a documentary. You had to make a documentary about this, because if you made this like into a movie, nobody would believe it. If you threw down a script to do this movie, that you say, here, I'm going to present something for you. Here's my treatment for a movie about this girl that has one illness, and they refuse to, the hospital believes she has it, but then suddenly they change and don't believe she has it, and they torture her, and that leads to the family breakup, that leads to her mother taking herself. They would go, yeah, this is just no, this isn't, we're not going to make this movie. That would just, nobody would buy it. That's just a bad idea. That's what this is. And again, during this whole thing, these lawyers are being incredibly inappropriate. They're being incredibly nasty, incredibly mean, and unethical. And that's something that I've harped on so many times. You have to be ethical. You have to be above reproach in what you do. Because if you don't have your reputation, what you've got nothing. It doesn't matter. It doesn't matter how good of a person you are. It doesn't matter how philanthropic you are. It doesn't matter how much your family likes you. If you don't have your reputation, you got nothing. I mean, you've got your word and your reputation. If your word means nothing and your reputation means nothing, you got nothing. Lily Smith, thank you. You've been a member for 14 months. That's a long time. Thank you, Lily. Hate your music, love your streams. Well, sorry about that. Our intro music is what it is. But I'm glad you like the streams. And the reason we do the music in the intro, the reason we do that is because it takes a while for YouTube to get its engines running and to send out the notifications. So rather than either jump into it and people miss the first 5-10 minutes, or just sit and stare at the ceiling and talk about inane things, I do the intro and then I talk about inane things. That's what I do. All right, I've downloaded this. Let me give me a quick second here. Sorry for the rough start. Now where I put it is where I downloaded it to. That's the question. This it? That's not it. I have to go back and look and see what the see what the title of the document was. See Nov 5th. Okay. Sorry everybody. Scroll on through. I really should have taken care of this before, but just in case, I'll download it again. Here's the folder it's in. Oh, okay. I put it in the wrong folder. That's how I roll. I put it in the wrong folder. There we go. All right, we're gonna go through the timeline here. There's 3 separate motions for sanctions, and this is going to give you some insight into really what a horrible group of people these people are. Now I'm trying to see how much of this I can read, because this is all right. This first motion for sanctions that was filed on November 1st is 327 pages long. That's the first motion. So we're gonna read some of that. We're not gonna read all 327 pages. We're not gonna read all of it. Don't worry. All right. But by the way, now that we're all up and running, we got 333 people. Hey, we're halfway to Satan. We're halfway to 666. Let's see if we can get Satan numbers. We're at 331 now because 2 people just left. But we got 198 likes. You guys are awesome. I haven't even shilled for likes yet. But if you haven't hit the like button, please do. I promise. Now we're going to get into the part where you'll like. This is where the liking starts. So that's awesome. Please hit the like button. If you haven't subscribed, I would just love it if you would do me the honor of subscribing. It costs you nothing, and it makes me happy. We're moving in the right direction. We've recently got up over 69,000 subscribers. And really quickly, when we finish with this horrible case in about an hour, when we finish this in about an hour, we're going to roll over and we're going to watch some information. We're going to watch a deposition in another horrible case. This is a case where the judge has just gone rogue. There's a YouTube family called the Hales, husband and wife. They do storage unit things, and they just kind of they just document their day on YouTube. The What the Hales channel. They're sort of being set upon by a woman who moved in across the street, and they're in a back and forth battle with her. They take it to the court, and the judge has gone rogue. The judge has gone rogue in that case, and we're going to be watching the deposition of the woman, which is just, it's unhinged. It's literally off the hook. So that's what we're going to roll into after we do this. And let's see, we got everything out of the way. Right. If any, by the way, super chats are not requested, not required, but they are just graciously, and as I say, always gratefully accepted. If you roll them in, it'll guarantees that I'll see your comment. Because when I do these readings, when I do the reading of the documents, it's hard to pay attention to the chat at the same time I'm reading something, plus making sure we're still up and running. So I don't see a lot of the comments. But if there's something that you feel is very, very important, or you just want to say something, the super chats do get ready because they've come up in their bright, pretty colors, and that catches my eye. And they also get automatically starred. And it guarantees that I will read and respond to whatever you say. But otherwise, I'll do my best to see what's going on. The party is next Friday. The 69,000 subscriber party is next Friday. Right. So let's bring up the first motion, the big one, the long one. The 327-page motion. And let's dive into what a bunch of snakes and just demons that the hospital's defense team are. Let's see. What's happening? I will take another. There. Now it's not going to melt my face off. All right. Dang it. I'm so professional. I don't even clean my glasses. Had a long night last night. It was a long Friday night with Aussie Overlord, who I see here is in chat. Hey, brother, it's good to see we're both alive. It was a night. Excuse me while I just clean off the goggles. All right, we're good. Hey, now I can see everybody a little bit better. There we go. Hi, everybody. Oh, before we get going, American Dreamer. I'm here. Though it's not a cult. Yeah, we're not a cult. We're not a coven. That's what we have. Danny on direct. She has a cult. But Megan Fox, she named the nurses that took care of Maya the 7th floor coven. Right. Here we are. Plaintiff Jack Kowalski's motion for sanctions. And this details some shiz. Let me tell you that. I shall embiggen this slightly and embiggen myself slightly. Well, that is the opposite of embiggening, isn't it, for the document? And if we scroll up, nope, just clipped it a little bit. Other way. Yeah, there we go. Or we can do this. Keeps getting smaller. Nope. All right, I ruined it. Let's go. We're done. Done messing around. Let's jump into this. Plaintiff Jack Kowalski's motion for sanctions. Plaintiff Jack Kowalski moves for sanctions against defendant Johns Hopkins All Children's Hospital defendant on the following grounds. Joseph Corcoran, that's Dr. Corcoran, the doctor with the immaculate hair. Plaintiff through counsel Gregory Anderson presented testimony of plaintiff's expert witness, Dr. Joseph Corcoran, on direct examination. In response to Mr. Anderson's question, Dr. Corcoran began to explain that the guardrails for clinical teams and standards of care for hospital management are set forth by the Centers for Medical and Medicaid Services, CMS. Defense counsel immediately requested to approach the mention of CMS. Thereafter, the following exchange occurred among the court and counsel. We're getting a look into the sidebars. So this is, we don't get to see into the sidebars much, but that's what this is. This is stuff that happened outside, the presence of the jury, and the cameras and all the microphones. Dina, thank you so much. Hey, from Seoul. Well, hey, in Seoul, what's your special drink? Who cares? It's 10 a.m. ish. I'm in Korea. Well, It's coffee. It's nice Ethiopian coffee. All the special drinks happened last night with Aussie Overlord. it's coffee today. So Mr. Hunter. Mr. Hunter. We don't like him. CMS standards were not referenced that I can recall in this gentleman's report. Hunter's on the bad team, by the way. He's on the hospital team. They were never referenced in his deposition. They're not on the exhibit list. They're part of several regulations. They are not permitted to use evidence for cause of action in a medical malpractice case. This is the first I've heard about CMS regulations with this witness. Mr. Anderson, Greg Anderson, hero that wrote this, CMS regulations and his involvement simply goes to his background, training, and experience on the specific types of policies and procedures here. We're not going to be comparing them or doing anything like that. Just wanted him to be able to explain his involvement in developing standards because I think it's important in the overall background, training, and experience to review these standards and evaluate exactly what happened. And I want to make clear that where his testimony is going, we're not micromanaging here. We're looking at the big picture of how this hospital got where it was to be as we determined a rudderless ship. The hospital's a rudderless ship. That's a very generous way of saying they're effed up. We're not going into rewriting all the standards in this case. We're talking about the way the hospital was structured and how the accountability was set up. And these standards, he had some developments. Then the judge says, well, no comparing and contrasting CMS policies. He says, no, we're not going to compare and contrast. It's going to be based on his background, training, and experience, and his statements as to what the standard of care and what is the standard of care under these circumstances. Mr. Hunter says, it sounds to me like what he's saying is he's going to identify the standard of care based on CMS standards and based on his expertise in developing CMS standards, which is more like a teeny inch away from what we're talking about. Anderson says, here's my problem. Here's the problem. Anybody who would be qualified enough to talk about this is familiar with CMS standards. So you can't get somebody who is going to talk about overall hospital management without them having some familiarity with these. It's just background, training, and experience. Mr. Anderson, says the court. Mr. Anderson, says the court, give me your word that you're not comparing and contrasting them. CMS is some sort of bench post. I understand. And present, I don't see anything objectionable from the witness. Hunter says, I've got a feeling we'll be back. That's probably a certainty, says Mr. Anderson. Then he resumes the questioning. And then Hunter makes an objection because I said, I had nothing to do with this is the witness. I had nothing to do with developing the CMS standards, but these really are. There's a book referred to, titled CMS Conditions of Participation, and these are the standards that every hospital is held to. Your Honor, he says, sustained. And then they ask to approach. If you can hear the dog chewing on the bone back there, I apologize. The dog has picked up a bone, but we'll just, the crunchy munchy noise is the dog. Then they have this big back and forth here again. And they're explaining to the jury, this joint commission is one by, there's a bunch of other things. And we're scrolling on down here. Mr. Anderson testified over objection in response to Mr. Shapiro's questions. Let me talk to you about the overall view of, based on what you've reviewed, did it appear to you, based on the materials you reviewed, the records, the policies, that all Children's Hospital had an appropriate safety plan in place for patient care? Well, yes, they did. And within a reasonable degree of hospital administration probability, did you believe from an operational standpoint that all Children's met acceptable standards of care? The witness says, yes, I did. They go to cross-examination, and then there's another exchange here on the bench. He says, okay, well, it sounds like there was a specific request for the documents that this expert relied on. So from a discovery standpoint, the judge is going to demand that they get all of these documents in. The hospital has until 6 p.m. today to get everything that this witness relied on to the plaintiffs. The court orders them to give everything that this witness is relying on to the plaintiffs. And Mr. Shapiro says they have every single document that he relied on, and I can read them to the court again. But I can remail them. Well, thank you. That's fine. Thank you, says the court. Mr. Shapiro says, well, we can remail them in the next 10 minutes. And the court says, and again, this witness will remain, and if we need to call him back, we'll do that. So, but for now, are you ready to go? I know you don't have these documents, but you'll have them sometime today. So we're as ready as we can be, because they haven't seen the documents. So it kind of makes it a little difficult to cross-examine on things if you don't have all the documents. And just to be clear, he was never sent joint accreditation documents. He didn't rely on joint accreditation documents. So I don't know that there's anything that they're going to expect to get other than what I read. Depositions of Dr. Perno, deposition transcripts, Fourth Amendment complaint, Eighth Amendment complaint, the hospital records, Sally Smith's medical evaluation, all children's policies. The court cuts him in. Mr. Shapiro, if the witness relied on documents, they need to go to the plaintiffs pursuant to the document request. They seem like very fundamental issues. I totally agree. I'm just making the record for the court. They have every single document he relied on. He didn't rely on the Joint Commission documents. Well, what you're reading is what you provided the witness, which is a little bit different than the document request. So I've said what I said, 6 p.m., if not before, let's do that. They go into cross-examination. And then the question, so did you actually get any of the JCH or the Joint Commission reports on Johns Hopkins All Children's Hospital? They're referring to the Joint Commission. That's the document that they said this guy never saw. Yes, the Joint Commission, of course. I did not see their full report. No. You saw experts of the report. I saw comments in materials I received referencing the Joint Commission. Yes. So you offered an opinion to the jury without actually reading the entire reports, right? I gave an opinion based on what the findings of that report seemed to be. The information I saw was provided by the attorney, but it had comments. It was medical record information and other types of information, depositions and like. That's the materials I received. Oh, so what's that? It looks like he actually received this thing that the court just said that he didn't the court just said you have to turn over everything, and the defense said, well, we didn't give him that, so we don't have to turn that over. And this goes on and on and on, where they're told to give things, they don't give, whether they're told to submit these reports, they don't submit them. They keep delaying and delaying the submission of these documents that should have been turned over immediately. And I want to get into more of the just the bad, nasty stuff. Because they're just horrible, horrible people. Defendant's production pursuant to the court's November order. All right, that's Angela Green affidavit. I'm sorry, we're just scrolling through here. My other one was all nice and highlighted. I remember that. Key testimonies of the Green, the hospital's holding all kinds of campaigns and education things and town hall meetings. And the defendant has presented a false impression to the jury. Yeah, Haley, well, this is like basic discovery. It shouldn't be that difficult, right? But see, this is, people don't want to give and with discovery, you are required to give everything, whether it helps your case or hurts your case, to the other side, everything relevant to the case. But strangely, you kind of don't want to give the documents that are damaging to your case to the other side. But you just have to. But sometimes the lawyers will try not to, and they find themselves in trouble. Before we move on real quickly here, Duncan, Idaho, thank you so much for gifting 5 Legal Vices memberships. If you got one of those 5 Legal Vices memberships from Duncan, Idaho, please give him a super special thanks. That's so deeply appreciated. Thank you so much. And D. Watt, who's been a member for 1 month. You hear that, Mr. Anderson? That's the sound of inevitability. That's the sound of your death. Goodbye, Mr. Anderson. Or it's not, because in this case, Mr. Anderson, just like Neo, crushed the enemies, crushed them hard. And Rosalind Duke has also just given 5 Legal Vices memberships. While we're paused here, if you get one, who got these? Sarah Gould, you got one. Pluckett got one. Sadie got one. Kitchen Knife Rescue got one. Hey, Kitchen Knife Rescue. Good to see you here. Been a minute. And L, just the letter L, got one of those. If you're one of those 5 people, make sure you give Rosalind Duke a super special thanks. I'm going to actually try to do a members only stream tomorrow. So it'd be, well, I guess it would be today for you. I got to figure this out. Sunday morning, my time, Saturday night. Okay, yeah. So probably Saturday night U.S. time. If not, it'll be Sunday morning U.S. time. But we'll do a little hour or so members only stream. So stay tuned for that. Without question, the defendant has presented a false impression to the jury about the defendant's compliance with Joint Commission and federal patient safety officials, quality, and risk management standards. In other words, see, this is Greg Anderson being a very, very nice guy, saying that they lied to the jury. they created a lie and presented it to the jury. Mr. Anderson's lengthy description. Wait. Greg Anderson is just one of the nicest people. And I love him as a wordsmith. He gets in a lot of snark when he can. He can be very, very subtly snarky, sort of like the super razor sharp knife that you don't know it's been inserted between your ribs until they pull it out and you see the blood and you go, oh. And like you do with a paper cut where you don't even realize that you have a paper cut until you see the blood and then it starts hurting like a mofo. That's Greg Anderson and his wordsmithing. You don't know, you think he's being complimentary, you think he's being nice, and then you go back and you read it and you're like, hey, wait. That's his writing style. Mark Anderson. This isn't Greg Anderson. This is Mark Anderson. Mark Anderson's lengthy description of the Joint Commission quality review, how arduous it is that the defendant is accredited after going through the arduous process, was presented for no purpose other than to convey the impression that the defendant now meets and has always met the Joint Commission's and CMS's high standards. They didn't. They were this close to having their accreditation ripped. And that's what they didn't want to talk about. That's what they didn't want to turn over, was these documents showing just how close they were on an imminent list, which is then you're in imminent danger of having your hospital's accreditation ripped. Yeah, so you don't want to show that to the jury when you're trying to show how awesome your hospital is and how you did everything possible to take care of this young girl and you did nothing wrong and nothing negligent. Meanwhile, there's records that show your hospital's been on the brink of having its accreditation ripped. Mr. Shapiro's cryptic statements to the court on November 1st that what Anderson's testimony was that the hospital is certified by Joint Commission, that's it. That ignores both the witness's lengthy predicate about the arduous quality standard-based accreditation process and that Mr. Anderson gave an incomplete description of defendant's accreditation status and the results of federal audits when he omitted the 2018 finding of immediate jeopardy. That's what we were just talking about, this immediate jeopardy of having their accreditation removed and the systemic organizational issues that led to such egregious and widespread failures. We know from Mr. Green's affidavit and deposition, including documents produced at her deposition, that the immediate jeopardy findings and notice and the defendant's corrective plans were not limited to the cardiac problem. That was also that was just in the cardiac. It has nothing to do with this. Well, it did. From that, we know Mark Anderson's testimony was at best a half-truth on material issue that the defendant carefully prepared and put to the jury. In other words, they craftily prepared what was essentially a lie to give the jury a false impression of what happened and the hospital status. And we know from the cross-examination of Mark Anderson that his testimony was a half-truth because he gave only he was only given selected information by defense counsel rather than complete information. Yeah, well, I didn't. Anyway, well, I don't. I don't want to digress too far here. The self-reports to the Joint Commission, the site visits to both CMS in Atlanta and AHCA in Tallahassee in December 2018 by senior patient safety and quality representative of Johns Hopkins All Children's Hospital, the resulting surveys of the defendant by CMS, AHCA, and the Joint Commission, and the acknowledgments of Johns Hopkins Children's Hospital regarding its systemic leadership and cultural failures as set forth in the various corrective action plans. And various remedies are available to the court to address the false impression created by defendant through Mark Anderson's testimony. Where a party has presented misleading evidence in a proceeding, the court has a range of remedies to address prejudice to the proceedings and to punish the conduct. That's what this is all about. This is about punishing the conduct of the lawyers who put together this and did all of these horrible things. And this is, like I said, this is only the first one. We've got two more. They're much shorter than this, so we can read through those. Two more motions for sanctions, which is making the lawyers pay money. It's time for the lawyers to pay up for their mishandling of this, for their unethical and improper methods of pursuing the defense of the hospital. And as we'll see in the latest filing, bar complaints. They want the judge to take this to the state bar. These remedies, in descending order of severity, are as follows. The first most dramatic remedy is striking a party's pleadings and dismissal of its case or defense where the false evidence goes to the very core issues at trial, and the conduct of the party is sufficiently egregious. There's a lot of cases that support that. This is generally reserved for instance of fraud on the court, shown by clear and convincing evidence. A fraud on the court occurs when it can be demonstrated clearly and convincingly that a party has essentially, wow. Greg, just it's not Greg's fault. This is quoting from a judgment. So it's not Greg's fault that the judgment, this original judgment in this case, could have just said has knowingly set in motion some unconscionable scheme. That kind of sounds like J Hatch, doesn't it? You know, the Johns Hopkins sort of sounds like their defense, an unconscionable scheme calculated to interfere with the judicial system's ability impartially to adjudicate a matter by improperly influencing the trial or unfairly hampering the presentation of the opposing party's claim or defense. That sounds exactly like J Hatch. Becca Lynn summarizes it quite well. J Hatch tried to put this doofus on the stand to say that J Hatch had a perfect record. On cross, it came, he read like 6 pages, like a 6-page report the lawyers had given him to tell him what to say. That's a good way of putting that. That was very succinct. Greg, you should hire that person to put things succinctly. But again, this essentially, anyway, the court rejected the plaintiff's argument that witnesses were merely mistaken when they testified that all documents had been produced, and instead found that this is not a reasonable explanation for the false testimony given by all 3 representatives of plaintiff GIRL on this important issue. So that's the legal standard. The sanction of dismissal is not limited to misrepresentations, says Greg Anderson, made only by the parties, but may also be imposed for misconduct of counsel. That's where we're going with this. The second district advised where counsel is involved in the conduct to be sanctioned, a causal analysis is required before dismissal is used as a sanction. The causal factors are, the causal factors are as follows. Whether attorney's disobedience and willful, deliberate, or contumacious? I don't even know what the hell that means. Judges, come on. What the hell does that mean? I'm 54 years old and I'm Googling a definition of a word in a judgment. Contumacious. What the hell is contumacious? Archaic law. You think that's it's an archaic legal term. You think, especially of a defendant's behavior, stubbornly or willfully disobedient to authority. Well, there we go. His refusal to make child support payments was contumacious. Wow. All right. Stubbornly or willfully disobedient. See, the judges usually have their clerks write judgments and things, and I guess the clerks go, "Oh, let's find a thesaurus. Let's find a really cool way of saying stubbornly or willfully disobedient." All right, so it's essentially, whether the attorney's disobedience was willful, deliberate, or stubborn, rather than the act of negligence or inexperience. So, all right, so it's not an act of neglect or experience, it's intentional. That's the first factor that has to be met before you can use this sanction against lawyers personally. 2, whether the attorney has been previously sanctioned, whether the client was personally involved in the act of disobedience, whether the delay prejudiced the opposing party through undue expense, loss of evidence, or in some other fashion. 5, whether the attorney offered reasonable justification for noncompliance, and 6, whether the delay created significant problems of judicial administration. In Ballard, the Second District ultimately remanded for the trial court to conduct a causal analysis, but not before noting that the trial may well have been justified in entering the trial court may have well been justified in entering a judicial default based on a finding of bad faith. The Second District and Florida Supreme Court have provided guidance for the trial's causal analysis. A trial judge's finding of willfulness may be based upon the record before him and his personal observation of the conduct of the non-complying party and counsel. So it doesn't just have to be based on the facts. The judge can also rely on their personal observations, their personal opinions when deciding whether or not to do this. The Florida Supreme Court found conduct prejudicial to the administration of justice where the conduct was contrary to honesty, justice, and good morals, and amounted to a violation of Rule 35.1b of the rules regulating the Florida bar, which reads in relevant part, in the absence of unusual circumstances, misconduct will not be regarded as minor. In other words, it's going to be major. It's not minor misconduct if any of the following conditions exist. The misconduct resulted in or is likely to result in actual prejudice to a client or another person. The misconduct includes dishonesty, misrepresentation, deceit, or fraud on the part of the respondent. Candor toward the tribunal, that's another rule here, reads in relevant part, a lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law. If you can't intentionally make a false statement to the court, that gets you in some serious effing trouble. But sometimes it happens accidentally. Sometimes you can accidentally make a false statement or present something that turns out not to be true, but you have an affirmative duty to go back and correct that false statement. And if you don't, this puts you in the hot seat. Or offer evidence that a lawyer knows to be false. A lawyer may not offer testimony that the lawyer knows to be false in the form of a narrative unless so ordered by the tribunal. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence that the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. Lesser sanctions, which the court has discretion to fashion, can include striking the misleading testimony, allowing latitude to the opposing party to introduce evidence on rebuttal to correct the false impressions, and 3, awarding attorney's fees in favor of the opposing party for necessary discovery. Now, the information contained in Ms. Green's affidavit was withheld by defense counsel. Here's where we get into the specific allegations against the defense counsel and the request for remedies. The information contained in Ms. Green's affidavit was withheld by defense counsel in its entirety, even after the court's directive to turn everything in any way related to the findings of immediate jeopardy immediately, and not until demanded by plaintiff during Ms. Green's deposition. Because the defendant chose to present Mark Anderson at trial, the only reasonable inference is that defense counsel withheld the requested information for the purposes of eliciting misleading testimony from Mr. Anderson, perhaps without his knowledge. Again, Greg Anderson giving the other Anderson the benefit of the doubt that perhaps the witness, Mr. Anderson, wasn't in on it, and or limiting plaintiff's ability to conduct a meaningful cross-examination of Mr. Anderson at trial, or otherwise rebut the defendant's suggestion to the jury that Johns Hopkins All Children's Hospital has always met accreditation in federal patient safety and risk management standards. Ultimately, the defendant left the jury with the impression that during the relevant time of Maya's admission, J. Hatch had always implemented appropriate safety plans and had an untarnished history of dealing with patient safety concerns, which we know is not true. Given the length of this litigation and enormous effort expended by both sides and the court to conduct this trial, it is galling. That's a good word. We need more gall in our life. It's galling for defendants' counsel to claim that they did not know about or remember the immediate jeopardy notice issued by CMS upon multiple self-reports of organizational failures to the Joint Commission, CMS, and AHCA in 2018. It is vexatious. There's another good word. Greg, gosh, I love the way you put words together. It is vexatious for defendant counsel to claim that they did not carefully prepare the testimony summary for Mark Anderson to use so that he would not disclose the immediate jeopardy finding nor the corrective actions and drastic system-wide actions that were taken to address the patterns of harm and failures of leadership evident at Johns Hopkins between 2015 and 2019. So that's what the chat we just brought up said. I think it was Becca Lynn said that they put together this basic report, this basic testimony, I guess, summary for Mark Anderson. That's a good, just use the word that Greg used. A testimony summary. Here's what you should testify to. Let's not tell him about all the bad stuff, so he can only rely on the good stuff we put in the report. But for the fortuitous fact that Johns Hopkins, the J. Hatch patient safety problems and risk management issues were reported in the press to the extent that the CMS statement of deficiencies became a matter of public record, but for Dr. Corcoran's role at Brandon Regional Hospital necessitating his telephone coverage with J. Hatch's senior counsel, Ms. Crane, the complete facts regarding the Joint Commission's findings and audits conducted by CMS and other government agencies may never have been disclosed to this trial. So thank God this was reported. It was so bad. Thank God their performance was so bad that it was reported in the press. And if it hadn't have been, then we probably wouldn't have known about it. So the misleading testimony of Mark Anderson goes directly to one of the core issues at trial, and the issue that has taken this case up for review by the Second District Court of Appeal, the management of Johns Hopkins All Children's Hospital and the involvement of risk management in Maya's treatment at the hospital. The defendant's withholding of this information and the false impression created in the minds of the jurors upon defendant's counsel's suggestion that an appropriate patient safety plan was in place and federal and Joint Commission standards had been met, necessitates the severest of sanctions. He doesn't want to get him off light. He wants the severest of sanctions. In this instance, the court has already noted the long-standing relationship between defendant's counsel and defendant J. Hatch, at one that upon information and belief stretches back decades. So they're saying the lawyers have been working for J. Hatch for decades. It is improbable to say the least. It is improbable to say the least that defendant's counsel did not know about the finding of immediate jeopardy that threatened the hospital's very existence. Yeah, that would be very, very high up on the lawyer's list of things to be told by the hospital. If you get a letter saying you're one of the most prestigious hospitals in the country, but you may not exist very soon unless you get your shit together, you run immediately to your lawyer. So Greg is absolutely correct here. It's improbable to say the least that defendant's counsel did not know about the findings of immediate jeopardy that threatened the hospital's very existence. Defendant counsel admitted as much under the court's questioning. Second, the defendant has chosen this tactic of dissembling responses to keep away with critical evidence on an issue at the very heart of the plaintiff's case. The plaintiff has asserted for 5 years and pled that this was a rudderless ship, that there were severe issues in how Johns Hopkins All Children's Hospital was managed, including the gross negligence of risk management and senior leadership. The defendant has elicited from his expert an opinion that misled the jury on this central issue. This leaves the plaintiff and the court with few options. Clearly and convincingly, given the defendant's repeated objections to the plaintiff's attempts to explore the CMS findings and later introduction of the idea that the federal government stamp of approval had been given to J. Hatch, that the defendant was cravenly manipulating the judicial system. Cravenly is another really, really good word. Cravenly manipulating the jury system. Wherefore, plaintiff requested the court grant the following relief. Here's what the plaintiffs are asking for. First, striking defendant's answer and affirmative defenses and pleadings to arguments on damages. Second, a directed verdict on punitive damages should the jury find in plaintiff's favor on another false imprisonment or battery. Third, striking the testimony of Mark Anderson and giving the following instruction. We don't need to read that because it's all moot at this point. Fourth, and in combination with the above relief, permitting plaintiff to offer into evidence during his rebuttal case the evidence obtained in discovery from the defendant after November 1st, which would include this. And fifth, and regardless of the above sanctions entered, awarding plaintiff his reasonable attorney fees for his discovery efforts. And sixth, such further relief as the court deems proper. So that was what was asked for back in November. But why did we go through all this? Why did we read all of that now after the trial is over? Well, because that served as the basis for subsequent actions. They're all based on that big filing. So we had to get the basis of what was in there. But real quick, before we go on to the second thing here, we're about a little over halfway done here. I just want to say thank you to the 388 people that are here now. I haven't even put up a like and subscribe poll. We've already got 319 likes. So thank you so much for that. Appreciate you guys tuning in. Appreciate you being here and watching this. We've got 10 new members out of this. You know, you guys are awesome. Love you to death, all of you. So thanks for being here. Make sure you hit that like button and subscribe if you haven't already done so, because hey, I'm a likable guy. You know, I try anyway. I try so much that I plowed through that for quite some time, and now the coffee that was too hot to drink is probably too cold to drink. Yes, I don't mind cold coffee. I like iced coffee. I love iced coffee. It's just like the slightly above room temperature coffee that's kind of meh, and that's what this is. But hey, it's caffeine. And it's in a Lorax merch. It's in the Lorax merch cup. So you can get one of these. Wait, yeah. There you go. Oop. You can get one of those down there, and the description's in the link. The link to the merch store is down there if you're so inclined. But now I just full disclosure, I get nothing from the merch sales. I just you can set your price on just whatever the base rate is. So you can have fun stuff. If I were to even get something from it, would be like $1 a cup, and I sell like 10. This is just for you. I don't get anything from it. I think it's funny. Porcelain Thunder says, "I bet your breath is minty fresh." Yeah, you had to be on Aussie Overlord stream last night to understand that was a thing. All right, Vince Clortho, thank you so much, Vince Clortho, for being a new member again. I just think you get a new member every day. Thank you, Vince, for being a new member. Oh, and Susan Scattereggia has become, I'm sorry if I butchered your last name. Susan has become a new member as well to the Clean and Sober crew. Welcome to the Clean and Sober screw. Dang. Welcome to the Clean and Sober crew. So good to have you here. That's what I was trying to say. I should probably just stick to reading and not thinking. It's still far too early in the morning after a very, very event-filled evening, a very event-filled Friday evening. More coffee. Yes, thank you. Go to my carafe here. As you can see, the sun is finally coming up here. My dog is just being toasty and warm over there on this chair. I'm feeling charitable. We do a thing where if we get $100 in super chats, we unlock the pig dog cam. But I'm feeling a little generous today, so we can do that immediately. We'll just throw in the puppers here. Give me a quick second to bring up dog cam. All right, there we go. And position. And there we go. We'll bring my little companion here. This is one of my two bulldogs. If you don't know, this is Strawberry. So yeah, I'm located here in sunny South Korea. It is now 11:01 a.m. and we're just kind of getting the grill fired up. Now the caffeine that I had is hitting the system, and we got puppers there just sleeping in the sun, climbing up on the chair and sleeping in the hey Straubs, whatever. We'll hang out in a bit. Yeah, this is a free pig dog day. we won't hold the pig dogs behind the paywall today. All right, so that was the basis for all of this. That's the basis for all of these motions. Now we're moving up to the today times, to the modern times. This is a motion that was filed on December 28th, 2023. Let's bring up that screen. Okay. Right over here. And this one is larger than the other one. I had to back it off a bit. All right, me and Puppers are just kind of hanging here with you guys. This is, as you can see up here at the very, very top, e-filed on 28th of December, 2023. And this is the thing. This has nothing to do with what we're talking about, but I'll tell you what really, really irked me, and irked is another good word that we just don't use enough. We should be irked about a lot more things than we are. The defense, the J Hatch defense, had this penchant for filing these massive emergency motions and all of these other things right before major holidays. They had zero self-awareness that they were going to do nothing but piss off their own their own clerks for having to come up with these things, and their paralegals. They're going to piss off, well, they probably intended to piss off the defendant and ruin their lives, the defense counsel and the defendants. But they're also pissing off the judge by making these motions and these emergency motions that require immediate responses right before major holidays. They made sure, for some reason known only to God or Satan, whichever one the J Hatch lawyers represent. We think we know who it is because they allowed the hospital to throw the Eucharist into the dumpster. They threw Jesus in the dumpster. We can't sit with that. We can't have Jesus in the dumpster. But that's where they put him. They put the Eucharist in the dumpster, so clearly they worship Satan. Just kidding ish. Yeah, so they made sure the judge had no Thanksgiving, no Christmas, and no New Year's holidays. They made the judge work on Thanksgiving, Christmas, and New Year's. Why would you do that to a judge? Do you just actively want the judge to hate your ass? Sorry, judge, you don't get to spend Thanksgiving, Christmas, and New Year's with your family and friends and loved ones. You have to read motions. You have to prepare for your hearings. That was just dumb. It was just idiotic for them to do that. And Lynn S., thank you so much for the generous super chat. Remember that Shapiro said he thought he had put this topic to death. Yeah, it's the vampire. It's Dracula keeps coming back. Thank you so much. That is Lynn's third super chat on a live stream ever. YouTube sends these little notifications now that lets you know milestones. And that was Lynn's third super chat ever. Thank you so much, Lynn S. I appreciate that. And again, Susan, thank you so much for becoming a member. Oh, Lynn, you're so nice. Thank you. Right. The motion to strike and motion for sanctions. Plaintiff, again, this is like the end of last year, right after ruining the judge's Christmas and just before ruining his New Year's. But Greg gets this in. Plaintiff Maya Kowalski individually, Jack Kowalski individually, and Jack Kowalski as personal representative of the state of Beata Kowalski by and through the undersigned counsel hereby move to strike the defendant's filings for a subpoena for juror interview. in violation of this court's December 2023 ruling. Again, they wanted to bring in juror number 1 and crucify him on the stand and prove that somehow it was juror misconduct because he was living with his wife and perhaps sleeping with the jury foreman was sleeping with his wife. They were saying he was online, he was doing all this research. It was completely debunked by everybody involved. And the defense counsel is saying that there was impropriety with juror number 1 because, like, just 17 years ago, this lawyer represented either him or his wife in some divorce proceedings. And we'll talk about that a little bit later here. But that was so egregious that lawyer that they said represented him came in, she filed an affidavit. And this affidavit she filed was absolutely withering. Because remember we were talking about how when you make false statements of fact, you have to go back and correct it. Well, there's also this thing that this ethical responsibility that lawyers have, that if you do something wrong, you can be sanctioned. But also if you know that another lawyer is doing something wrong, this is a thing. You have an affirmative duty to rat on that lawyer. If you know a lawyer is doing something illegal, immoral, unethical, whatever, and you allow them to do it, you can be held responsible as well. It's sort of like aiding and abetting a crime, but is aiding and abetting an ethical violation. So yeah, if you know a lawyer's doing something wrong, you literally have to rat them out, or you can be disciplined for not ratting them out. And this lawyer, she came out of the woodwork and filed an affidavit to say, as an officer of the court, I have a legal obligation to correct this lawyer's lies to the court. These lawyers knew or could have easily found out I had nothing to do with juror number 1, nor his wife. In fact, I was representing somebody that was in opposition to them. She said, and I want it to be reflected on the record that I fulfilled my duty to come and point out their lies. That's me paraphrasing, but that's what it said, because, as I said, if she knows it's untrue and they find out that she knew it was untrue, she can be held accountable. She wanted to say, I want to make it damn clear that I fulfilled my legal duty to affirmatively report and rat out these people for their known lies. This is how horrible these defense lawyers were, that you get people from 17 years ago going, wait a minute, I need to correct what they just said because they lied to you, judge, and they knowingly lied to you. And she said all they had to do to find out she had nothing to do with that case on behalf of juror number 1 or juror number wife or whatever was to just go onto the database, the court records, the court docket, and type in the damn case number. And it, like, when you do that, when you go to an online database and pull up the case, it will say plaintiff. Then right below that, plaintiff's counsel, and lists, defendant's counsel. All they had to do was type in the case number that they knew, and they would instantly see that she was representing someone in opposition to juror number 1. So it was a bold-faced lie to the court. Anyway, let's get on to this 28th motion here. I got all worked up. I hate it when lawyers do this. I hate it when they give other lawyers a bad name. It annoys the hell out of me and it makes me angry. And I think it's righteous indignation. But I just can't stomach it when lawyers do this. Plaintiff Maya Kowalski individually, and we already read all that, the court directed the defendant to redact any and all identifying information, including the physical location of juror number 1. Yes, they did. The judge said, get rid of their, because the first motion they filed had the defendant's address right in the footnotes. And the judge said, no, redact everything. Redact all information wherever they are. Defendant filed his subpoena with the GPS coordinates unredacted in violation of the court's orders. Yeah, the next filing, it didn't have the dude's address, it had the GPS location. Like down to the square meter where you can find the guy. The pattern of defense counsel's conduct in this regard is now prolific and intentional, having repeatedly made the personal information of juror number 1 public record in this case. Wherefore, plaintiffs move for an order to strike the filing date of December 26th, and for sanctions and for further relief, such as the court deems just and proper. That's the other motion. Now we get to today. This is the new filing, everybody. This is the important one. This is why we are here. All right, hit that like and subscribe, and let's get into this new filing that was filed on March 6th. So that was like 2 days ago for most of you, 3 days ago for me, because I'm in the future. Plaintiff supplemental motion for sanctions and consideration of bar referral. We're going after their licenses. We're going after suspensions. Not just money. We're gonna bring it home. For defense counsel's deliberate misrepresentations and elicitation of false testimony and other conduct. So here we go. All these people move the honorable court to consider and make such referrals to the Florida Bar of Defense Counsel of Johns Hopkins All Children's Hospital as the court may determine to be necessary as a result of defense counsel's action in violation of Florida Bar Rules of Professional Conduct as set forth herein. Plaintiff's counsel is obligated to report defense counsel's trial conduct to the appropriate professional authority. That's what I was talking about. This is the duty to rat out. We are obligated to report their inappropriate professional conduct. The appropriate, okay, this is the bar regulation 4-8-3A. I had that up here a bit ago. Oh, there we go. Yeah, it's right down here. I don't have to bring it up. The appropriate professional authority for plaintiff's counsel report is this court. So I have to report to this court the problems. Plaintiff's counsel is hereby making such a report by bringing this motion. The appropriate professional authority for this court to report the conduct is the Florida Bar. So we're reporting to you, court, and now, court, we want you to report it to the bar. We have to report to you. You have to report to the bar. These reporting obligations are mandatory. Judge, we're required to tell you, and you, judge, are required to tell the bar about this. It says a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct must inform the appropriate professional authority. Exactly what I just talked about. You have an affirmative duty to rat on your colleagues. It's a mandatory duty. If you don't rat, you go down with them. So here we are, we're ratting on them. And with glee and pleasure, we are informing you of their nastiness. Prior to bringing this motion, plaintiff's counsel has reviewed the trial testimony, arguments, and trial exhibits, including defense counsel's admission that material evidence concerning J. Hatch's accreditation status and federal, state, and accreditation agency scrutiny concerning J. Hatch's patient safety, risk management, and cultural failures was withheld from defendant's expert on hospital administration. Resulting, this is what we just went through at the beginning for the lengthy thing. That's what this is relating to. Resulting in the elicitation of materially false testimony. Plaintiff's counsel has also interviewed witnesses to defense counsel's disparagement of the jurors and related comments prior to bringing this motion, and has determined that under Florida Bar Rules of Professional Conduct, the undersigned is left with no choice without committing an ethical infraction themselves. We have no choice but to do this. Otherwise, we're just as bad as they are. So we're reporting you. Plaintiff's counsel is bound to bring to the attention of the court the actions of defense involving direct and knowing misrepresentation of material facts. The issue of defendant Johns Hopkins All Children's Hospital status with the federal government and with the reviewing organization, the Joint Commission, responsible for reviewing hospital operations and the quality of patient care was at the core of defense counsel's, oh, here we go again, the contumacious scheme. Greg, now I know it's in the court. I know it's in the court judgment language that you're relying on, but you don't have to say contumacious. You can I love you, Greg. You're so awesome. The counsel's contumacious scheme to bolster the reputation of the defendant and create a false impression that his actions and organizational culture had already been reviewed by the authorities with the most power to consider its risk management structure and patient safety record, and that J. Hatch's management, including risk management and patient safety record, were above reproach. Clearly, they were not above reproach. In fact, for a period of time, they were just a bee's dick away from completely losing their accreditation and ceasing to exist. Defendant's counsel fostered this false impression throughout the 9-week trial, first arguing to exclude the testimony of plaintiff's hospital management expert. To the contrary, based on the Center for Medicare and Medicaid Services, CMS, findings of immediate jeopardy and public doggy's happy, sorry, and public reporting of the same, and then eliciting false testimony from the defendant's hospital management expert to the effect that the hospital was and always had been in good standing with the federal government through CMS and with Florida State Agency's Healthcare Administration, AHCA, and the Joint Commission. After maintaining this position before the court and the jury through its elicitation of false testimony and direct misrepresentation of material fact, and after a ream of documentation were discovered to be in defense counsel's possession, proving to the contrary, defense counsel reluctantly admitted under questioning by this court that the documents reflecting the true status of J. Hatch's organizational culture and patient safety record were withheld from the defendant's hospital management expert and never disclosed to the plaintiffs. They eventually were forced to admit that. This court confronted defense counsel over the withholding of information from the defendant's expert and the elicitation of false testimony resulting from defense counsel's action and questioning. The court, let me ask you this. Let me cut you off. Did you even provide witness Mr. Anderson with any information that we've been discussing since Wednesday afternoon? Yes, sir. He was provided the information because we had an issue with what was produced to Mr. Anderson. Witness Mr. Anderson. So I want you to be very clear about what specifically produced to witness Mr. Anderson, very, very specifically. So this is the judge. I want to know exactly, very, very specifically, what was produced to him, what was given to him. Mr. Hunter replies, since Wednesday. Since Wednesday, he was sent the certificates. I don't care what happened since Wednesday, says the court. At the time he testified to this jury, had the defense even provided any of the information that we've been discussing since Wednesday? May I ask Mr. Shapiro to address that, Your Honor? Mr. Shapiro, do you want to step into the breach here? Great Henry V reference. Once more into the breach. Mr. Shapiro, I can't do Shapiro. Megan Fox does Mashir. Well, only to the extent that he was provided hospital policies and procedures. Yes, sir. That doesn't answer my question. I did not provide him Joint Commission surveys, no. So I don't know if he looked at anything online, but to my knowledge, no. My understanding of his test, well, just to explain, my understanding of his testimony, Your Honor, is that the fact that the hospital was being operated at the time meant that they had gone through joint accreditation surveys. This is a simple basis of the court statement that he volunteered. Didn't even provide the information? Okay, what's next, Mr. Hunter? Sorry, that's the best Shapiro I can do. What became clear after the defendant was compelled to produce the documents, I'm sorry for that, is it had withheld was that J. Hatch had been placed in immediate jeopardy for its patient. Yeah, we didn't tell the jury that the hospital is on trial for negligence and shitty management and horrible stuff was in immediate jeopardy for ceasing to exist because of negligence and horrible mismanagement. For its patient safety risk management failures, and the CMS, AHCA, and the Joint Commission had each made findings regarding the organizational failures at J. Hatch. Further, the concealed documents clearly showed that J. Hatch's senior management recognized the cultural failures and took deliberate steps to counter J. Hatch's culture of fear and retribution that exacted swift punishment on hospital employees who spoke up on behalf of patients who had been harmed at J. Hatch. J. Hatch's corporate representative, Angela Green, testified that the cultural failures spanned at least 5 years back from the immediate jeopardy findings, including the time span of Maya Kowalski's admission, and that J. Hatch's interim CEO had independently validated the reports of retaliation and retribution directed at good faith actors within the organization. Yeah, people that came and spoke out about the hospital were crushed by the hospital. Their own employees that said, hey, we're doing things wrong. They were met with immediate and swift retribution. By misleading the jury and the court about defendants' accreditation status and compliance with patient safety mandates, and by sanitizing the information given to its expert witness, and then eliciting false testimony through the same expert, defense counsel was in clear violation of the Florida Rules of Professional Conduct that a lawyer shall not assert or controvert an issue therein unless there is a basis in law and fact for doing so. and a lawyer shall not make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made, and offer evidence that the lawyer knows to be false. And a lawyer shall not engage in conduct involving dishonesty, deceit, or misrepresentation. A second basis involves the statement of defense counsel disparaging the jurors and the Kowalski family upon rendition of the verdict, as well as those public comments of defense counsel further disparaging jurors in the court in the days and weeks following the verdict. This is some shit right here. This is where it's just nasty, shitty lawyers. And I'm sorry to curse so early in the morning, but it usually doesn't take me till 11:21 a.m. to get to the first cursey word of the day. This is where the lawyers are just dicks. They're just nasty, vindictive, mean, horrible, dickish people. Defense counsel referred to the Kowalskis in these outbursts as scumbags and the jurors as 6 people from the bus stop. 2 months after the verdict, defense counsel disparaged the judge through the local media, as reported by the Tampa Bay Times. Despite Tuesday's ruling, Ethan Shapiro, co-lead counsel for All Children's, said the hospital still plans to appeal the court's decision for as long as necessary. In a statement released Wednesday, he said the court had failed to grasp the complex medical, child safety, and legal issues in this case. Yeah, he basically said the judge was stupid. And fair and unbiased review of the facts and the law in this case completely vindicates the care provided by the experts at Johns Hopkins Children's, which it clearly doesn't. Shapiro said in a statement, "It's a sad indictment of the judicial process in this case that those facts were concealed and that the law was misrepresented to the jury." Yeah, accusing the judge of misrepresenting the law to the jury is a really, really bad way of doing this. Don't do that. Don't tell the judge he's stupid and he misrepresents law to the jury, because I guarantee you, judges don't like that. Defense counsel's public statements disparaging the court and the jurors, coupled with defense counsel's loud, profane outburst. Do we have the there was a very, very bad outburst in the court in the hallway after the judgment. Defense counsel's public statement disparaging the court and the jurors, coupled with the defense's counsel's loud, profane outburst while exiting the courtroom after the verdict about the plaintiffs and the jury, is a violation of the professional rules of conduct. Yeah, a lawyer shall not engage in conduct that is prejudicial to the administration of justice, including to knowingly disparage, humiliate litigants, jurors, witnesses, and court personnel or other lawyers. Emphasis added. The Florida Supreme Court's interest in ensuring that judicial referrals to the Florida bar are resolved correctly is demonstrated by the Supreme Court's October 2021 rule change, which now requires any judicial referral to the bar that does not result in a finding of probable cause or the filing of a formal complaint to be submitted for review and approval by the Supreme Court. The bar will submit the board's recommendations for approval of judicial referrals to the clerk of the Supreme Court as soon as practicable after the board's decision, but not later than 30 days. Referral of these matters to the Florida bar also makes practical sense. Not only do you have to do it, but it also makes practical sense to do it. Why? This court has neither the time nor resources to do the necessary thorough review of these serious matters to arrive at a result that is correct for the lawyers concerned and for our civil justice system. The Florida bar has those resources. So wherefore, the plaintiffs have fulfilled their ethical duties of reporting conduct as required. Again, that's the affirmative duty that if you know somebody is doing something, if I as a lawyer know that another lawyer is doing something unethical, wrong, or whatever, I have an affirmative duty to rat them out. Judge, we're ratting them out, because if we don't rat them out, we are in violation of another Florida bar rule that says we are violating our duty to rat people out. So we're ratting them out, and Judge, we want you to send this to the bar so that the bar can hear about them and consider the appropriate discipline that should be meted out to the J-Hatch lawyers. So, wherefore, plaintiffs have fulfilled their ethical duties of reporting conduct as required, and moves this honorable court to take those steps as the court determines are required under the rules regulating the Florida bar, insofar as referral to the Florida bar for further investigation. Submitted, dated March 6th, 2024, by Gregory A. Anderson. There you go. That brings us up to date on this breaking news in the Maya Kowalski case. We've got about 5 minutes left here. About 5 minutes, we're going to roll over and we're going to move into the What the Hail stream, which we need to set that up real quick. So, guys, I'm happy this is continuing. I'm happy that they're pursuing these sanctions against these lawyers. Because as I said, nothing irritates me and makes me angrier than lawyers behaving this way, lawyers behaving unethically, intentionally unethically, making people hate lawyers more than they already do. Lawyers should be doing everything they can to improve the profession, to be able to wake up in the morning, to look at themselves in the mirror and thinking, I am being the best lawyer I can be today. I'm being the best representative as I can of a profession that everybody hates until they need you. And only when they need you do you suddenly become their best friend. We should be doing what we can to make people think we're their best friend all day, every day. And they're not doing it. And it makes me so angry. And I hope that these J-Hatch lawyers are crushed by the Florida bar. I would like to have seen some great fines being handed down from the bench. I still hope we get that, but I would like to see some public discipline. I would like to see them publicly disciplined, suspensions, whatever. But at very least, a very public reprimand. I don't know why I just turned that subscribers only mode on. I think that was for the next stream. But anyway, dang. Manders, maybe we should see if Legal Vices will do a TLDR at the end of this stream for those looking for another case. TLDR of what? Of this? Of what we just talked about? Well, it's just too late because I did it all. I don't know. Now, I meant to turn on the sub only for the next stream that we're going to be flipping to here in 1 minute, but I accidentally did it for this one. Oh, Lynette. Oh, yeah. Okay. Right now we're going to flip on over to the What the Hails case, where this is a giant YouTube community. They've got about 750,000 subscribers, and they move to this place. This lady moves across the street, apparently tries to grift from them. They say, no, that ain't going to work. And then she goes nuts. And it's just been this big back and forth where they've got restraining orders against each other. Things are going poorly. This woman is not exactly in her right mind. She's an older woman, 61 years old, with some sort of weirdly adopted or not adopted 4-year-old living with them. She was a stripper and a preacher, which is why the thumbnail is a stripping preacher for the show. She's a stripper and a preacher. She's not in her right mind. She's acting pro se for the first little bit, but on her own without a counsel. She eventually gets a lawyer, but we're going to be watching her deposition. The deposition does not go well. So we're going to automatically be funneled over there right now. So when we shut this down on replay, you're just on your own. But if you're here watching this live, we're going to be sent over there. If you don't get sent over there automatically, there's a little blue box that's going to come up above chat that says, hey, something's happening over at Legal Vices. Click here and find out. If you click there and you still don't get directed over there, then just find it yourself. You don't want to miss this. This is odd. It's insane, quite literally. So mods, thank you for being here at our usual Friday evening U.S. time, Saturday morning Asia time. Great to have you here. Chat. We got 500 or so of you we had up here at one point in time. Thank you so much for being here. Deeply appreciated. We are up to date now on the J-Hatch Maya Kowalski thing. We'll keep you advised of developments as they occur. Chat, thank you for your support. Thank you for being here. Vice Squad. Hey, Kurt. Uncivil Law, just saw him here. Hey, Kurt, what's up, brother? Good evening to you. You, chat, are the greatest chat on the entire internet. You are the Vice Squad, and I'm glad you're here, and I love to see you all. Let's go on over to watch more of me. We'll see you soon. Legal Vices, the Law Racks, and Strawberry saying peace out.